Hearing in the Queen on the application of against the Secretary.
Ms Gallifant.
Well, my days, good morning. I appear together with Tom Mountford and Gayatri Sarathi for the appellant, instructed by Naren Singh, Araldo Datri and Anne Collins of Clifford Chance, acting pro bono. The respondent is represented by Sir James Eadie QC and Sarah Hannock QC, instructed by the Government Legal Department. The intervener appears by Monica Cars-Frisk QC and Rachel Jones, instructed by George Hugh Braid from Macfarlane's, again acting pro bono. I say at the outset how grateful we are to the court and to the court staff for accommodating our request for an in-person hearing. It's enabled the appellant to be here together with the appellant's partner, David. I can set out the background to our appeal relatively shortly, not least because we've set it out at relative length in our written case. The appellant identifies a non-gendered person. From childhood, the appellant, who uses the pronoun person, became progressively detached from the gender assigned to the appellant at birth. The appellant completed transition to non-gendered status 30 years ago after 2 rounds of surgery, the second of which was provided by the National Health Service. The status of non-gendered is recognised as a type of gender identity not only by the NHS but by the Respondent Secretary of State herself, whose evidence is that one's gender identity is one's innate sense of gender, which could be male, female, both, neither, or fluid. Some 25 years ago, the appellant first sought a passport with a declaration of neither male or female, which the appellant was told at that time was not possible. 16 years ago, the appellant discovered, with the assistance of the appellant's MP, Simon Hughes, that the International Civil Aviation Organisation permitted passports to be issued with X, standing for unspecified, rather than male or female, M or F. Correspondence ensued between the appellant's MP and Her Majesty's Passport Office without result until 2014, when the HMPO undertook an internal review of gender marking in passports. The court has that in the core volume, page 561. The HMPO identified 8 concerns which might arise with permitting X passports, none of which are now relied upon to justify their non-provision. That's internal paragraph 54, page 567. Following that internal review, Her Majesty's Passport Office maintained its policy that an applicant for a passport must declare their gender/sex as being either male or female, and a passport will only be issued bearing a male M or female F indicator in the gender/sex field on the space of the passport, and it will not be issued with the unspecified X gender marker permitted by the International Civil Aviation Organisation standard. These proceedings started 4 years ago after considerable further correspondence between the appellant and the respondent, and following the recommendation of the House of Commons Women's and Equality Select Committee that the United Kingdom must follow Australia's lead in introducing an option to record gender as X on a passport. The respondent primarily resisted the appellant's challenges based on convention rights on the grounds that the appellant's right to identify as non-gender was not protected by Article 8 of the Convention. The Secretary of State's position was that the only persons whose right to gender identity was protected are those who identify as exclusively male or exclusively female. That argument was rejected both at first instance by Mr. Justice Jeremy Baker and in the Court of Appeal, where Lord Justice Irwin described the proposition as completely untenable. Paragraph 123, at page 284 of the core volume. The convention issues before this court are therefore now first whether the policy breaches the appellant's right under Article 8 to respect for the appellant's private life, and secondly, whether the policy breaches the appellant's right under Article 14, read with Article 8, not to be discriminated against on the grounds of gender and or sex. I start with Article 8, and at the beginning of the analysis is the question of how one should view the interference or obligation, that is, whether it would be regarded as a positive or negative obligation analysis. At first instance, Mr. Justice Jeremy Baker first considered whether a positive obligation arose. He concluded it did not. but found that even were the issue to be looked at through the lens of a negative obligation, the outcome would have been the same. It says, as the question of fair balance lies at the core of the analysis and the factors which had to be considered were the same. That's paragraph 131 of the judgment below, 331 of the core volume. The Court of Appeal followed the same approach. It focused on the issue of positive obligation, but found that even if the issue was considered as a negative obligation, there had been no interference, and if there had been interference, it was justified. That's paragraph 113 at page 283 of the core volume. Now, we obviously disagree with those conclusions, but in principle we say it is unsurprising that they found that the outcome was the same, whichever lens they considered the issue through, because we say that the principles applicable to assessing a state's positive and negative obligations under the Convention are similar. That appears stated clearly in the case of Hammerleinen, and this is an authority, no doubt, which we will become very used to looking at. That's in the Primary Authorities, Volume 1, Tab 4. It starts at electronic file numbering 732, and I pick it up, if I may, at 747.
If it helps you, Ms. Gallifant, we don't have any paper documents, so we're purely working off the electronic file numbers.
Oh, well, that's fine. I will simply give you the file numbers. I wasn't sure if one had hyperlinks that took you to the tab, which might be quicker, which is why I was endeavouring to give both, but I shall speed up by not even having to mention them in that case. Thank you. So, page 747. And starting at paragraph 64, it was in that case common ground that between the parties that there had been an interference with the applicant's right to respect for her private life, that she was not granted a new female identity number, and the Chamber also examined the case from that point of view. But the Grand Chamber in Hammerleinen was of the opinion the question to be determined was whether respect for the applicant's private and family life entails a positive obligation on the state to provide an effective and accessible procedure allowing the applicant to have her new gender legally recognised whilst remaining married. So the Grand Chamber considered it more appropriate to analyse the applicant's complaint with regard to the positive aspect of Article 8. The Grand Chamber then moved to consider the general principles applicable to assessing a state's positive obligation and emphasised at the outset of paragraph 65 that the principles are similar when assessing a positive and a negative obligation. So regard must be had to the fair balance to be struck between the competing interests of the individual and the community as a whole, the aims in the second paragraph of Article 8 being of a certain relevance. Just pausing there, if the principles are similar, then what is the difference? Well, as noted in the dissenting judgment at 758, it is because the court grants states a wider margin of appreciation concerning their positive obligations than their negative ones. That's the internal paragraph 4. That's also clear from the earlier decision of Goodwin. That's at 704, and I'm picking that up at 721, paragraph 72, where the court recalls that the notion of respect as understood in Article 8 is not clear-cut, especially as far as the positive obligations inherent in that concept are concerned, and that having regard to the diversity of practices followed in the situations obtaining in the contracting states, the notions require... I'm so sorry.
Which paragraph, please?
Sorry, 72.
Thank you very much.
I do apologise. So, electronic page 71 and para 72. So this is the point being made by the court that the notions requirements will vary considerably from case to case, and the margin of appreciation to be accorded to the authorities may be wider than that applied in other areas under the Convention. The point is made similarly, and I'll just give the court, if I may, the reference in the case of X and Y in Romania, which is at page 861, in which the general principles applicable to the negative and positive obligations are described as being comparable. Now, I'll obviously return to the issue of the margin of appreciation in due course, but I emphasise at the outset that there is nothing in the authorities to suggest that when considering the interests of the community as a whole, in relation to a positive obligation, those interests go further than the aims set out in the second paragraph of Article 8.2, which were described as being of a certain relevance in Hämäläinen. I may then go back to Hämäläinen itself, and picking up again at page 747, there is no dispute between the parties as to the factors that are set out in paragraph 66 that go to factors considered relevant for the assessment of the content of positive obligations on states. At the top of page 748, one sees that some of them relate to the applicant. They concern the importance of the interest at stake and whether fundamental values or essential aspects of private life are an issue, or the impact on an applicant of a discordance between the social reality and the law, that the coherence of the administrative and legal practices within the domestic system being regarded as an important factor in the assessment carried out under Article 8. The court then turned to other factors which relate to the impact of the alleged positive obligation at stake on the state concerned. There are two factors: whether the alleged obligation is narrow and precise or broad and indeterminate, and the second being the extent of any burden the obligation would impose on the state. Paragraph 67 then goes on to consider the margin of appreciation that states enjoy in implementing their positive obligation, as it makes clear at the outset. Now, it's common ground that the case of Hämäläinen itself is an issue of implementation, by which I mean that the obligation on states to recognise the change of gender undergone by a post-operative transsexual through inter alia, the possibility to amend data relating to their civil status, had already been established in the case of Goodwin in 2002. And in Hämäläinen, Finland had made legislative provision for the legal recognition of a trans person's acquired gender. The issue for the court, therefore, was the means by which Finland had sought to achieve recognition of that right. And the particular issue was the requirement in Finland at that time that in order to be recognised and have their civil status recognised, a person who was married must either divorce or could convert their marriage into a registered partnership, and that was a precondition to legal recognition. And the question for the court was whether that fulfilled the positive obligation on the state. So it wasn't a question of whether a right to the recognition of their legal status was in play. That was determined by Goodwin. It was a question about the way in which a precondition had been imposed on the legal recognition. Now, we accept, as we did in the Court of Appeal, that the margin of appreciation is relevant both at the stage of considering whether a positive obligation arises, and thereafter, assuming that it does, the form and manner in which that recognition is to be implemented domestically. And that was set out at paragraph 88 in the Court of Appeal's judgment, page 277. Now, the Secretary of State emphasises that a question of recognition must not be allied with a question of implementation, as, she says, the factors set out in Hämäläinen may bite on each other in different ways. Now, we respectfully agree that it is important not to allied those two questions, but we say the Secretary of State is wrong to suggest that this case concerns an implementation question. The way in which the Secretary of State has characterised the difference between recognition and implementation is that recognition is the first step. It's a positive step, they say, at a low level of granularity. It is a requirement, for example, to accord status or recognition to a particular group. So we say, as in Goodwin. Implementation they describe as a specific step at a higher level of specificity, such as altering a birth certificate or introducing an X marker on a passport, which they say may be just characterised as the implementation of a broader obligation to accord status or recognition. We say the reason why the Secretary of State wants to describe this as an implementation issue is, as I've already indicated, because it is clear from, in particular in Goodwin, that even when Strasbourg accepts that a positive obligation arises, the appropriate means of achieving recognition of the right still attracts a margin of appreciation. And that's seen in Goodwin at paragraph 93, where they find that the margin of appreciation had effectively closed, such that the United Kingdom was required to recognise the legal status of a post-operative transsexual, but the court emphasised that the means of achieving recognition of that right lay within the state's margin of appreciation. But in this case, although we are concerned with a specific step, that is the provision of an ex-passport to a person in the position of the appellant, that step clearly cannot be characterised as the implementation of a broader obligation to accord status or recognition, for the very simple reason that the Secretary of State has never accepted, and to date the courts have not found, that there is any obligation to accord status or recognition to a non-gendered person in terms of a positive obligation. Indeed, the Secretary of State has never accepted that there is any interference with the appellant's Article 8 rights at all, perhaps unsurprisingly, given that until the judgment of the Court of Appeal, she didn't accept that the appellant had any such rights. We also note that this distinction between a broad obligation and a narrow and specific step isn't one that's drawn for these purposes by Strasbourg. And it's enough simply to point perhaps to Rees, which is one of the earliest cases in the run of cases leading up to Goodwin. In Rees, the applicant complained about a failure to provide measures that would constitute him as a male for the purposes of the exhaustive classification of all citizens into male and female. So that, on the Secretary of State's case, would be the recognition issue. That's the recognition of a right or a status broadly. But Rees also asked for the issuance of a birth certificate and complained about the non-issuance of a birth certificate, on which his gender should, he said, have been not that assigned at birth, but his acquired gender. Now, both were dealt with by the court as being recognition issues. There was no question of the second, on the Secretary of State's analysis, being an implementation issue. And we say that that's relevant when it comes to considering some of the Secretary of State's submissions on the limited target, as it's put, of the challenge, and the creation, if successful in this appeal, of a target against which further challenges might be brought.
Will you at some stage tell us precisely what is the target, whether it's for one group, in which case define, or more groups, and specifically what the measure is in relation to, just so we're totally clear?
Yes, of course. Well, I of course, appear on behalf of the appellant, who is a non-gendered individual. So our starting point is that the positive obligation...
How do you... The issue of definition really begins there.
It does. And a non-gendered individual is a person who identifies neither as male nor female.
So it's simply self-certification.
It is self-identification. Can I commend to the court, and perhaps I've skipped on rather faster, can I commend to the court a very helpful part of the intervener's written case on terminology, which may be of assistance. At page 232 of the core bundle, there is a very helpful summary of commonly used definitions which set out the difference between sex and gender, and then the question of gender identity. And I don't know whether it might be helpful for the court just to read through paragraph 7 to 12 at this point, so that we can be clear about, as it were, when I'm talking about non-gendered and those principles of what I'm saying.
I think this is pretty familiar to us.
I'm grateful. Well, you'll see at paragraph 12...
And the passport is concerned with...
Well, the passport says sex, but it is recognised as applying equally to gender. So in countries where an ex-passport has been provided, it has been provided not just to people whose sex is neither M or F, but whose gender is not either exclusively M or F.
Does the appellant reject any identification by sex as male or female?
Well, the appellant would, yes, because the appellant's gender identity is how the appellant defines themselves. But the whole point about the passport X...
Well, the distinction, I mean, as you explained to us, an individual's sex is generally determined at or before birth based on physical characteristics. as distinct from sex, gender refers to socially constructed characteristics. So one can readily... no, there's a distinction there, and the passport is expressly concerned with sex.
Well, the ICAO guidance on machine-readable passports does
Why
define...
are we interested in guidance given by an international air travel organisation about how machine-readable technology should be designed?
Well, we're interested because the Secretary of State's own evidence is that they follow the position set out, and the reason for the passports that are produced by the United Kingdom is in order to comply with the guidance. So that's why we're interested in it, because as a starting point, it would be very complicated if none of us had machine-readable passports anymore, and that's why passports are produced in the exact format that's required by the ICAO in order that they can be read by machines in other countries. So the starting point is that the guidance is followed. The guidance, however, is not followed in the sense that the guidance provides for an X marker for unspecified, but the policy, of course, does not.
But where it says unspecified,
Yes.
are cisgender people also able to put an X in that in a country where it's allowed, or is it only for people who are inter?
It depends upon the rules of that particular country, because it is up to the country to identify what parameters should be met in order to have an X in your passport. So we say that it certainly captures the appellant, someone who identifies as neither M or F. And in some ways that's an easier example, because if you neither identify as an M or an F, then we say that's why it should be X for unspecified. Now, it seems to us, in theory, possible that a country could consider that a cisgender person could have an X in the passport, if that were the country's policy. There is nothing to prevent the country doing that. But equally, a country could say, no, there has to be a self-identification or a letter from a medical practitioner or the like. That is a matter of implementation. And that's why I draw the line between the question of the engagement of the positive obligation in the first place and the question of implementation. So in theory, yes, it would be if a country took the view, which is, actually, one should simply be able to say, I don't want to put my gender on a passport. We don't say that's this case, because, of course, we do say that's a matter ultimately for the government.
But assuming the government took the view that self-certification by somebody who was clearly male or female was not appropriate, they would have to define the X's and require a method of establishing it, or what?
Well, the government would be free to identify a system and a scheme of rules that set out who was entitled to have an X passport, so long as that respected the Article 8 rights of those applicants. So that's why I say, from our perspective, it's an easier starting point to say, well, for this particular applicant, the appellant, who identifies as neither M or F, we say that that should be enough.
So if the government is free, this is a possibility, which is what we're concerned in. It's knowing exactly what your target involves.
Yes. So I think my lady put to me two questions. One is the target. The target is the measure. It is the measure of not providing to any person, because it's a blanket rule, no one can have an X. At the separate point that my lady put is, which is the affected class. And we've set out the affected class in our written case, because we do say it goes beyond the circumstances of persons in the same position as the appellant, who are non-gendered, and that logically we say it would also pertain to the groups that we've set out. Sorry, let me just find the reference there. I'm so sorry, Yes, I'm so sorry, I was going further on. It's in fact paragraph 2. Paragraph 2, we say that includes non-gendered, non-binary and intersex persons and others whose gender identity is neither or neither exclusively male or female. That's the affected class, and we've identified that further at paragraph 12 on page 157. But we say that that is entirely consistent with the Secretary of State's own evidence, which the Secretary of State has identified gender identity as being potentially male, female, both, neither, or fluid.
Thank you.
Thank you. And I'm also very helpfully reminded, my Lord Reed's point, and I was going to get to the application form for the passport in any event. The application form is at page 608. And as it were, consistently, again, with the government's approach to the question of gender identity, page 608, this is the online application form. One sees at the foot of that page, after the name, title, first and middle name and surname, is gender. So on the application form itself, it's not defined as sex, it's defined as gender. And that gender must be either male or female.
And if you click on help on this?
That's a very good question. I don't think anything happens. I'm sure it tells you something. I don't think it tells you anything relevant. Can I just come back to that moment when one of my juniors has done the clicking? I'm sure we have clicked, but I think it was so irrelevant we've forgotten it, but I'll come back if I may. I'll come back and
No, in your own time.
I'm being better. I'll come back if I may in a moment. Thank you. So I was going to move on to the question then of factors that are relevant when considering whether or not positive obligation arises, which picks up on the points that my ladies and my lord have been asking in relation to the factors relating to the applicant. And the first of those factors, as identified in Hämäläinen, concerns the importance of the interest at stake and whether fundamental values or essential aspects of private life are an issue. Now, the Court of Appeal found that the issue of gender identity is now widely accepted as being of central importance and at the heart of a person's Article 8 private life rights. That's paragraph 57, electronic page 271. The court, though, found that the judge's assessment of the importance of the interest at stake could not be criticised. Again, that's set out in the judgment itself on page 271 at the top. And the judge's assessment was that although passports could be used for identification purposes outside use as a travel document, so too could birth certificates, which would not be affected by a change to the policy. And the judge in the High Court found that that was likely to be considered of more fundamental importance upon the issues of sex and gender. We note, first of all, that, of course, the passport is the only document that allows a UK citizen to access all the manifold advantages of being able to travel abroad for work, career, family, or leisure. We note also that, of course, it's entirely right that a passport could be used for identification purposes, but that doesn't recognise the full extent to which it is used. And it is helpful to go back to the cases leading up to Goodwin once again, because in Rees, and that is at page 2194, in Rees, at paragraph 20, it was noted that a passport is a normal type of identification document used in the United Kingdom. So by contrast to countries where there is a civil identification document, in the United Kingdom, the passport is one of the documents usually used. It's at paragraph 20. It is equally clear that the use of birth certificates for identification purposes has been discouraged, and birth certificates carry a certificate and a warning on them that they are not evidence of identity. For that, I don't imagine it will be in dispute. Sheffield and Horsham, another one of the cases running up to Goodwin, page 2236, paragraph 20, and Goodwin itself, paragraph 26, which is on page 713. So we say that so far as the analysis is concerned, it is right that passports can be used and are regularly used for identification purposes, but it is wrong that a birth certificate would ordinarily be used for such circumstances, given that they are not, and especially said not to be, evidence of identity in the same way as a passport. As to the learned judge's suggestion that there's more fundamental importance of birth certificates on the issue of sex and gender, we note, of course, that the issue is not a comparative one. The question is whether the particular facet that is being considered and the impact in relation to the particular measure which is impugned gives rise to and concerns an important interest at stake involving fundamental values. In the case of B and France, which starts at 1972, I may pick it up at 1998, the nature of the complaint was the non-correction, paragraph 43, of civil status entries which obliged the applicant to reveal intimate personal information to third parties and resulted in her facing difficulties in professional life. I also note that paragraph 55, which is on page 2002, the second subparagraph within paragraph 55, the court noted that the applicant had undergone surgical operations abroad, which involved the irreversible abandonment of the external marks of Miss B's original sex. And the court also considered that in the circumstances of the case, the applicant's manifest determination is a factor which is significant to be taken into account, together with other factors with reference to Article 8. We say the same is true of the appellant here, having undergone 2 surgeries for the same purpose of removing any sex-specific characteristics.
But you're not asking us to confine any decision we make to people in that particular category?
No, my lord, I'm not. But I'm simply saying, I put my case at its highest because I say the appellant's case, I say, is clear. If the government were to wish to have gradations, then it may do so. I would only mention that, of course, and we can see as we go through some of the other cases, reliance upon surgical intervention has increasingly, the trend is very firmly in the opposite direction so far as recognition of trans persons are concerned. So it would be surprising at this stage were the government to adopt a position which is that surgical intervention is required, but that would be a matter ultimately for the government and subject to any arguments were that to happen. But I do say that in relation to this appellant, when talking about this appellant's rights, this appellant's manifest determination, as it's described, is also a relevant factor as per the decision in B in France. At paragraph 59, going over to page 2003, the applicant, and this was the complaint in relation to documents, the applicant stressed an increasing number of official documents indicated sex, extracts of birth certificates, computerised identity cards, in community passports, etc. Transsexuals could consequently not cross a frontier, undergo an identity check, or carry out one of the many transactions in daily life where proof of identity is necessary without disclosing the discrepancy between their legal sex and their sex. Now, I accept, of course, that the context is different in the sense that there is no identity card, whereas there is in France system. And I also accept that the particular issues in relation to I can call it the NISEE, that is effectively the national insurance card, doesn't arise in the same way in this country. But the principle that's articulated in B in France is the same. The appellant, whose gender identity engages Article 8, cannot cross a frontier, undergo an identity check, or carry out one of the many transactions of daily life where proof of identity is necessary without using a passport which misrepresents the appellant's gender identity. From the perspective of the individual, the dysphoric effect is twofold. It's the making of a false declaration to obtain the passport, and then each subsequent occasion of presentation of the passport. In relation to a birth certificate, so far as presenting a document to an officialdom or a third party is concerned, there is less harm in respect of one's presentation to the outside world because it doesn't need to be presented every time. And indeed, since it carries a rider saying it's not for identification purposes, for many things it wouldn't be acceptable identification. And of course it's not photographic identification whenever that is required.
But could the government say, well, we want to define sex in a particular way and not allow people to self-certify?
Well, I'd say it would be surprising if they did that, given the way in which the Strasbourg jurisprudence approaches that question when it comes to transsexual persons. I say that would be extremely surprising. But as I've indicated, our starting point is a much more simple one, which is we know that the individual's right to identify as non-gendered is protected by Article 8. And so the starting point is, does a positive obligation, which we say is similar in context subject to a marginal appreciation, to the negative obligation, require then that that individual be entitled not to specify something that that individual considers to be ultimately wholly false, M or F. So the government could choose to create a category of persons eligible for an ex-passport, but we do say that that category would have to include the appellant.
Yes, I mean, it had some question in my mind about whether it did involve a misrepresentation, because is it not asking for sex at the date of birth?
It can't be asking for sex at the date of birth because a transsexual would be able to answer that according to the acquired gender.
Right, with that exception, because of course that's a different case.
Well, it's a different case, but it's relevant for two reasons. One we say is then you can't, it can't be right that this question is always about gender or sex assigned at birth. It can't be that. And the second point is that for a trans person to obtain a passport, no surgery is required. All that is required is a letter, and I can come on to this, is a letter from a general practitioner, from a medic. So the threshold required to have an M or an F in your passport is very low currently, and it's exactly the point, my lady, I'm about to go on to, which is it always has been for trans persons. So I say that actually the category of persons who have always been able to change from an M to an F is highly relevant when considering the respect we say that is owed to a person who identifies as neither M or F. That the government has had no difficulty with those trans persons. And can I pick that up in Goodwin, my lady?
Can I just ask,
Yes.
So they don't self-certify for the purposes of obtaining a passport. They require some sort of medical certificate.
Can I take my lord through it? I think it might be helpful to go through it by stages, because I can deal with the position as set out in the authorities and then the position following gender recognition certificates, which I think might be helpful to show the development, if that's appropriate. Goodwin itself, then, set out, moved up at paragraph 65, which starts at page 721. The government's position. So this is the government's position, of course, in 2002. And this is before any other decision. So the previous decisions of Rees and Sheffield and those decisions have all gone against the individual trans persons, so far as recognition is concerned. So the government expressly accepted that there may be specific instances where the refusal to grant legal recognition of a transsexual's new asexual identity may amount to a breach of Article 8, in particular where the transsexual as a result suffered practical and actual detriment and humiliation on a daily basis. And the reference there, the footnote there, 13, is a reference to be in France, which I've already taken my lords to. So that's the question of having to provide someone with a passport and identify using official documents on a daily basis for ordinary life, as in that case, male when the individual's acquired sex was female. The government, though, denied, in the case of Goodwin, that the applicant faced any comparable practical disadvantages, as she had been able, inter alia, to obtain important identification documents showing her chosen names and sexual identity, and I emphasise sexual identity, e.g. new passport and driving licence. So back in 2002, the government positively relied upon the ability of a trans person to be able to change their name and sexual identity on a passport as a mitigating factor. In other words, they had done something that would prevent there being the detriment and humiliation on a daily basis that might otherwise have been the case and was the case in France. Now, the appellant cannot obtain either of those identification documents, a format that doesn't involve making a false representation and presenting themselves in a false way as either M or F. And to pick up my Lady Arden's point, it is clear that it was done with the minimum of formality. And one sees that, I'm sorry to jump around in the authorities, but going right back to the beginning of Rees, which appears in the bundles from page...
At some point, you're going to give me the simple factual information I asked for, whether the various groups of people you're describing, including transsexual people, obtain these identification documents on the basis of self-certification, or whether they require their application to be supported by some objective evidence.
Yes. What is said in relation to Rees, because what we have now is the evidence following gender recognition certificates, and I'll come on to that in a moment, if I may. In Rees, it is described as being a minimum of formality. So we're told that that they can simply change them as being from Mr. and Mrs. and Miss and vice versa, and their gender with a minimum formality. That's at paragraph 20.
Sorry, Ms. Calvin, I'm having difficulty hearing you.
Oh, I'm so sorry. I'm talking at my bundle. So in the decision of Rees, which is the first of the series of cases to make it to Strasbourg, in the decision of Rees, the passport, the change of gender in a passport is described as being available to a transgender person with a minimum of formality.
Giving us the judgments isn't really terribly helpful. For example, I've got Goodwin in front of me, and it's talking about paragraph 65, legal recognition of a transsexual's new sexual identity. Now, that may in itself be referring to a particular category of people. Not all people who identify as having a different gender from their sex at birth are in the same position.
Well, my lord, it's certainly the case that up until Goodwin, it was only these cases are only concerned with post-operative transsexuals, and then there's a series of cases that deal with transsexuals who do not wish to have surgical intervention, and their rights are equally protected under Article 8. So my general position is the rights of originally post-operative transsexuals are protected, the rights of non-operative transsexuals are protected. And we know, because the Court of Appeal confirmed, and we say it was clear in any event, that the rights of an individual who identifies as non-gendered are protected under Article 8. So we say that the principles are applicable. Now, I have said, of course, my lord, that when it comes to implementation, there may be different questions. But the starting point is that the principle of engagement of Article 8 for each of those categories of persons is clear. My lord wanted to know what has to be done now in relation to the application. Let me just, if I may, take my lord to the information at page 597. Which is the guidance by HMPO on applying for a passport for transgender and transsexual persons. And we can see at page 598, applying for your passport under that heading, about a third of the way down, you can apply for a passport in an acquired gender. This option is available to those who do not hold a gender recognition certificate or have not had gender reassignment surgery, as well as those who have.
And just to interrupt, just for information, a gender recognition certificate, I take it, is a statutory certificate under the legislation dealing with gender reassignment.
Exactly, that's right. So that's the principle. So you can have this irrespective of whether or not you have a gender recognition certificate. And if you, my lords, turn to page 599, at the foot of that, one sees the final sentence. If you do not have or cannot obtain a full birth or adoption certificate in your acquired gender, so in other words, if you haven't got a gender recognition certificate such that you have a birth certificate in your acquired gender, the position is that you will need to include the following of your application at the top of page 600, your full birth or adoption certificate in your birth gender, so we're able to determine your right to nationality. I emphasise again, the word gender is used rather than sex. Any other documents outlined in the guidance booklets, and either the gender recognition certificate or a letter from your doctor or medical consultant confirming that your change of gender is likely to be permanent, and evidence of your change of name, of course that assumes a person has changed their name, such as a deed poll. So that is the requirement now under the guidance. It isn't clear from the earlier cases as to whether there was previously required to be a letter from a doctor. It was referred to as being a minimum of formality. But what has never been required is a birth certificate showing acquired gender. And what is not required is that that individual has had surgical intervention. I'm sorry, my lord, if I took a little while getting around to my lord's point, but I hope I've made it there now.
Thank you.
So just then going back to, if I may, the question about the significance of passports, and I've emphasised, of course, that the government previously relied upon the ability to change one's gender in a passport as being a factor why there shouldn't be a positive obligation requiring full recognition in terms of civil status. The Court of Appeal rightly recognised that the issue isn't simply bearing the passport, it's also the application itself. And that is the judgment at paragraph 58 on page 271. And to make that good, I wonder if I might just ask my lords, I need to turn up the application form in its electronic form at page 608. Sees that, we've already gone to that, my lord. That form then requires gender, and I'm afraid it's split into two parts. The declaration that follows at the end of that electronic form is almost at the very other end of all your bundles. It's at page 3065. Oh, 66. Sorry, I'm being told I've given you the wrong reference yet again. It's 3066. 68. I was just going to, if I may, just pick up 66 first. There's one point also to pick up. 66 is, if you give untrue or misleading information to get a passport, you could be prosecuted. And again, 68 then, the declaration, you confirm the information you've given is correct. And if you give untrue or misleading information to a passport, you could be prosecuted and you have to agree. So that's the declaration. My lords and ladies also have the hard copy form, so one can see what that looks like at 3065. And that equally provides a declaration, it's slightly fuzzier to see at the top, I'm afraid, that makes it clear that it's a criminal offence to make a false statement to get a passport. The person making the declaration at paragraph 6 declares that, as far as I know, all the information I've given in this application is correct, and that is the declaration that must be made on a hard copy. Now, the point is made by the Secretary of State that, effectively, setting aside the question of passports, and we say that the relevance and significance to the individual is quite clear, both from B in France, but also from the Secretary of State's own position in Rees, Goodwin, Cossey, and the previous cases, where it was a positive factor, they say, that an individual was able to have a passport in their acquired gender. The Secretary of State says, well, there's no disadvantage that arises from the policy of not allowing a person to have an ex-passport in relation to employment or pension rights or the ability to enter into a civil partnership. Now, we entirely agree and recognise that the policy doesn't create such a disadvantage. But we say, far from that being a point in the Secretary of State's favour, it supports the applicant's position. Because this is a case akin to B and France, where and we'll come on to, the balancing of the rights in that case were against the state's alleged burden and the obligation on the part of the applicant to reveal personal information to third persons. That is the way that their, as it were, burden, their impact on them, was characterised in B in France. So B in France wasn't based on any complaint about underlying substantive rights or pension or employment or civil partnership. B in France was equally a targeted complaint, primarily about documentation and the adverse impact, the detrimental adverse impact, on a daily basis. As I've emphasised, the government accepted that there could be such an adverse impact in principle, but that it didn't apply, they say, in cases such as Rees and in Goodwin, because of the ability to have a passport and an acquired gender. So we say it is exactly the same in principle as the position in B in France. And of course, in B in France, the court did find that there was a positive obligation which the state had failed to fulfil. And we say that is because it balanced a limited right against, in that case, the absence of detriment to the respondent state. So the fact that this doesn't concern pensions or employment or the ability to enter a civil partnership is no reason not to recognise that a positive obligation may arise in relation to the measure impugned, that is, the policy which precludes in any circumstance the issuance of an ex-passport. The second of the factors, if I may go on to the second factor identified in terms of impact on the applicant in Hämäläinen, is the discordance between the social reality and the law, the coherence of the administrative and legal practices within the domestic system being regarded as an important factor. The references in Hämäläinen are to B in France, which of course I've already gone, and again to Goodwin. And if I may invite my ladies and my lords to turn back to Goodwin, page 722. The impact on the individual is considered under section 2, paragraphs 76 through to 80. And here, at paragraph 77, it must be recognised that serious interference with private life can arise where the state of domestic law conflicts with an important aspect of personal identity. And the court referred to the stress and alienation arising from a discordance between the position in society assumed by a post-operative transsexual and the status imposed by law, which refuses to recognise the change of gender, cannot be regarded as a minor inconvenience arising from a formality, a conflict between social reality and law, which places the transsexual in an anomalous position in which she or he may experience feelings of vulnerability, humiliation, and anxiety. And it's in this context, when considering the applicant's position, that the court in Goodwin dealt with this question of coherence, and that's at paragraph 78, because in that case, the applicant's gender reassignment had been carried out by the NHS, recognised the condition of gender dysphoria, and provided reassignment by surgery. There is no difference here between transsexuals, a non-gendered person, The NHS recognises that as a type of gender dysphoria and has, in the case of the appellant, carried out assignment or non-assignment by surgery. And the court in Goodwin was struck by the fact that that there was, in those circumstances, despite the gender reassignment which had been provided by the state, which might be regarded as the final and culminating step in the long and difficult process of transformation, there was no recognition in law. And it's here that the Strasbourg Court emphasises the importance of the coherence of the administrative and legal practices within the domestic system, which must be regarded as an important factor in the assessment carried out under Article 8 of the Convention. And what they find illogical there is, why would a state authorise treatment and surgery, indeed finance the operation, but not recognise the legal implications of the result to which the treatment leads? And we are, of course, only asking for one particular type of recognition and the measure, but we do say the illogicality remains the same. So the state has assisted in the appellant no longer having any sex-specific characteristics and funded that, recognising it as gender dysphoria and fully recognised as a particular gender identity. However, the illogicality is then the individual, the appellant, is not able to obtain a key document which recognises the acquired identity, i.e. non-gendered. So we say, firstly, as a matter of fact, this factor, this criteria appears in the appellant's case, but secondly, as a point of principle, the Strasbourg's approach to administrative convenience is in the context of this disconnect between the state offering something on the one hand, the gender reassignment surgery, and not then following it through with any recognition in law of the effect of having offered that gender reassignment surgery. Before I move to the question then of administrative coherence, can I just emphasise the Secretary of State suggested that in considering factors relevant to the appellant, the Strasbourg Court has had particular focus on whether the conduct involves evolving values, interests and rights. We say that simply doesn't appear from either the cases relied upon by them or elsewhere. So those, we say, are the principles and the factual situations applicable to the factors relating to the appellant. We say that the factors are that the interest at stake is important and indeed a fundamental value, an essential aspect of the appellant's life is at stake.
So can I just be clear?
Of course.
You are saying that it is, by saying that Article 8 is engaged, one is saying that there is recognition that the status or fact of being non-gender is a fundamental fact of a person's identity.
Yes. And that's what the Court of Appeal found. Sorry.
That's what the Court of Appeal found,
yes.
And I think that's now conceded
yes.
by the Secretary of State. Then one has to say, well, what follows from that? There can be a whole range of things that the state can do or decline to do that follow from that, one of which is deciding whether or not the NHS should carry out necessary surgery, one of which is, you would say, putting an X marker, allowing an X marker. There may be other things which are more, or which would be described as trivial, not important. But the right arising from the rights arising from the engagement of others, therefore a sort of a bundle of rights, or potential rights, which exist if they can be described as not a minor inconvenience or giving rise to daily humiliation and detriment.
I would put it slightly differently with respect. I would say that the way the Strasbourg Court would would be to consider whether the threshold of engagement was met. So in the Stirner case that the government relies upon, I'll turn up the reference if I may in a moment, in that case, the government found that an individual's desire to change their name was effectively trivial. So Article 8, it wasn't engaged. So you could have a level of triviality where Article 8 wouldn't be engaged in the first place. That is
even if it was something that arose from someone's gender? Or...
No, I wouldn't accept that. So I would say, so if one is thinking about triviality, one can either filter something out at the first instance, such as a change of name. If one is concerned with a gender identity, I say that there could the right itself, as it were, could not be described as trivial because it goes to a fundamental value and an essential aspect of that individual. However, if the measure which was wished for and the impact on the applicant was so slight, one can see that Strasbourg might adopt an approach when you're going to the balancing question of saying, well, what you want is so trivial, you know, it's not a daily basis, it's not the sort of document you'd ever have to produce, that there's a sort of negligible impact. And that would be the question of, as it were, the importance of the interest at stake. So I can see a distinction there. If you were asking for something that really was trivial, Article 8 would still be engaged in that context because it concerns gender identity. But you might, in theory, have a position where the interest at stake was so trivial that the impact on the state of having to provide you with a different coloured bus pass, whatever it may be, you know, something completely trivial in the mind of the court or the convention, that there the balance would be completely disproportionate.
But at what stage of the chain of reasoning does that kind of consideration come in?
Well, I think it's common ground between myself and the Secretary of State that it comes in at this point when you're considering the impact on the individual, because there are two elements to it identified in Hämäläinen. One is the importance of the interest at stake and whether fundamental values or essential aspects are an issue. We both agree that now fundamental values are at issue because it concerns the appellant's gender identity. But the Secretary of State's position is this isn't an important interest at stake. A passport is not important. They say full recognition, birth certificate.
Yes, no, I understand that. So, but if again, the question is, at what stage are we considering whether or not the interest is important or not? Is it to do with whether it's a positive or negative obligation? Is it to do with the margin of appreciation? Which element of the claim is it to do with?
It's one of the factors that you consider in whether or not a positive obligation. And we say that's what is intended to refer to both the importance of the interest at stake and whether fundamental values are essential. So we say it captures both of those elements. Yes, I must just make sure that the case that I referred to, Stirner, is not a trans name check case at all. It's simply an individual. It wasn't to do with his gender identity at all. It was a family. So sorry, perhaps you don't look at the garden path, but the sense of triviality, the example of a differently coloured bus pass, something of that level, one can see that at that point the question of the interests of the applicant are going to be minimised if it's something so trivial. But we say we don't get anything close to that.
Yes, but I'm just to press you again. If you were in that situation, the claim would fail because of the failure, not because Article 8 is not engaged, but because there's no positive obligation when you balance
exactly
the burden of providing it benefit.
Yes, exactly. And there'd have to be something to be balanced against it. So let's imagine it might be perceived as trivial. If there's actually no burden on the state, there might be a different analysis arising in any event. But I would absolutely accept that the triviality, the significance of the impact on the appellant and the interest at stake, that is something to be taken into account in that balancing exercise. And we say, for this appellant, in the context of passports, it weighs very firmly and emphatically in the appellant's favour, as was recognised by the Secretary of State in Goodwin by placing some emphasis on the ability of a trans person to obtain a passport in an acquired gender.
One can readily imagine contexts where the issue would be of greater importance than it is in this case. For example, if the appellant committed a criminal offence resulting in a custodial sentence, and it was a question of what type of prison to send the appellant to, or in relation to pension entitlement. You're obviously confining your argument to passports. Are you accepting that, because although contexts like prisons and pensions, searches at airports, so one can imagine a whole range of really quite traumatic situations, but where it may be more difficult to adapt the current approach quickly than it might be in relation to passports. The way you're presenting the argument, as I take it, you would be content for the court to reach a decision purely in relation to passports, while leaving to one side, not addressing at all what the implications might be in other contexts.
Yes, I would. And I say that because we are not seeking full recognition in the Goodwin type way for every purpose. We are seeking it in a limited context. We say it is open to us to do that, not least because, and I'll come on to the impact on the state, is we say negligible. So when one weighs those rights against each other, we say it is clear that a positive obligation arises there. We absolutely recognise that there may be any number of other questions in a wider context. That is precisely why there is a greater margin available to all states, particularly following Goodwin, as to what to do about those complicated, there in the context of post-operative transsexuals, very complicated issues about the repercussions of full legal recognition of the acquired status. So we don't say there is actually anything different in principle between our position, where we say, well, we have, as it were, a limited challenge, and there may be, in another context, any number of other complicated issues that might arise, then to Goodwin, which, although albeit full recognition, made it very clear that actually those repercussions, those questions, I mean, they have still been challenged and articulated in Strasbourg and continue to be. So questions such as the rights to same-sex marriage arising out of it, which is, of course, the case in Hämäläinen itself. So those difficult questions are always going to arise, even when your starting point is full legal recognition. So we don't say there's any difference in principle. We are asking for the positive obligation only in one context at this point. Other arguments are for another day and another context.
Well, but if you define the positive obligation as arising because a person has presented as a particular gender or self-certifies, then it may be that that right will have a domino effect.
Well, I'm sure that the appellant would be delighted were it to have a domino effect.
It makes the court impossible for the court to confine its attention to the passport only.
We don't accept that at all, because a domino effect is a necessary effect. In other words, if I knock over the first domino, everything else goes. And that's why I say I'm sure the appellant would be delighted. But everyone recognises that isn't the way that these sorts of rights develop.
Mm-hmm.
Imagine that I'm successful in this appeal. There will be a finding that in the particular context of the right at stake, so in relation to the passport, in relation to the daily distress and detriment of having to present in a way that does not reflect the appellant's gender identity, which is protected under Article 8. That finding will be limited. Now, it would be for another case, another claimant or whoever, to then consider there is another area in which they consider that actually there would be a positive obligation arising. To consider whether or not an obligation arose elsewhere one would have to look at a different set of factual circumstances. And to go back to my Lady Rose's point, the interest at stake. Now, one can see that, for example, in my Lord's suggestion of pension rights, one can see that there might be very interesting and difficult questions as to the interest at stake and the burden on the state. Those are just the sorts of cases and sorts of arguments that happen following Goodwin. So I say the fact that there may be different arguments in different cases is no reason at all not to find a positive obligation in this case. Because
but positive obligation is at a high level of abstraction.
Well, it's not in this case, because we would say, and this is why the Secretary of State, of course, wants to say that it's actually at a very low, as well, it's a very specific step, and that's why they want to characterise it as implementation. And we say, well, we're entitled to, as per B in France, actually just say there's a positive obligation rising in relation to one aspect of the appellant's existence. That is, having to present, when using a passport, whether by way of a travel document or identification paper. And we say that the appellant, just as any claimant for the court is entitled to, is to challenge that separately. And I will absolutely come on, my lady, because what we have always said is there is no necessary connection between the policy, which is, of course, a policy under the royal prerogative in relation to the issuance of passports, and any other aspect of law. That is a question that the Secretary of State has indicated they think should be considered in the round. So the Secretary of State's position is it would not be appropriate to, or the state is entitled to, consider these matters in the round. But we say that isn't the question that should be asked for the purpose of the positive obligation, and it certainly isn't the question when we come to Article 14. So we do say that there is no inherent difficulty with finding a positive obligation in relation to the particular challenge, the nature of the challenge and the measure impugned in this case, and in theory not finding one in another context.
But then what do you mean? You've used the phrase full legal recognition in this is the starting point. But what does that mean if you accept that there may be some circumstances, even if you win this case, where actually the state would be entitled to say, no, that's a minor inconvenience and it would cost a lot of money to sort out, and so we're not going to do that?
If I have suggested that this is a case seeking full legal recognition, then I misspoke.
Well, you said you start from...
Well, I'm sorry, let me be clear. I start from the position that there has been full recognition in terms of the engagement of Article 8. In other words, that the gender status as a non-gendered person is recognised and protected by Article 8. What I seek is a positive obligation or recognition of a positive obligation in the context of a passport, which of course is an X for unspecified. So just to be clear, I am not Goodwin, as it were. I am not coming here to say, for all purposes, in all contexts of life, the appellants or any other non-gendered person's status should be recognised and the ramifications then flow to the government. What I say is it is both feasible and appropriate to constrain the challenge to a particular facet of the appellant's life. And I emphasise, of course, which is why we say that the balance is so clear in our favour, that X stands for unspecified. It does not stand for non-gendered or non-binary or gender fluid or any of those other types of as it were, wholly male or wholly female status. So when I talk about full recognition, it is recognition of the status. It is not that it should be recognised and in full civil terms. It's my error for using status in two different ways, in the Goodwin type way.
But you told us earlier, and you took us to your case at paragraphs 2 and 12, to the effect that this case didn't only concern persons who declined to identify as either male or female, but also non-binary and intersex persons and other persons whose gender identity is neither or neither exclusively male or female.
Yes, well, that is my case.
Right.
But, my Lord, the court may disagree. The court may think, well, there is a distinction between a person who is non-gendered and a person who is gender fluid. That ultimately would be a question for the Secretary of State, if the Secretary of State wanted to make that distinction. We say, logically, the same principle should apply, because all of those gender identities are recognised and now from the Court of Appeal, accepted by the Secretary of State as falling within the ambit of Article 8. Because of the concept of gender identity per se. So Strasbourg doesn't distinguish between a particular type of gender identity, whether it's non-gendered or non-binary or fluid. It is gender identity per se, and that's why the Court of Appeal and the High Court in this case had no difficulty finding that it was engaged. So we do say that all of the persons in those categories would, by the logic of our position and the logic of the Court of Appeal's position on engagement of Article 8, also be captured. But if the Secretary of State took a view that actually, for some reason, they were entitled to exclude some part of that category, ultimately that would be a matter for them and a matter of potential challenge. But I remain central to my case, which is on behalf of the appellant, which is the appellant on any view falls squarely within the category of persons who we say is entitled to an ex-passport because of the positive obligation that we do say arises in their position.
Could I ask you, you took us to paragraph 78 of Goodwin, which is
Yes.
page 722,
Yep.
where the Strasbourg court says the coherence of the administrative and legal practices
Yep.
within the domestic system must be regarded as an important factor in the assessment carried out under Article 8 of the Convention.
Yeah.
Is that not in some tension with what you've just been submitting about the ability of the appellant in this case to, if you like, pick and choose different aspects of the way in which their recognition should be given to their non-gendered status? You say you're entitled to pick on the passport. There are particular factors in relation to a passport which may or may not apply in other contexts, but paragraph 78 seems to be saying that actually it is relevant to have regard to other contexts in this sort of context.
Relevant in the context of the applicant, because here the very specific context in which the court made that comment is that the applicant there had had gender reassignment surgery, but as it were, despite the fact the state provided it, the state hadn't then recognised the legal status. So we say it's a factor that goes to the impact on the applicant, not a general factor. And I accept, of course, the Secretary of State, of course, relies upon this sentence, as my Lord has suggested, to the effect, well, then everything's up for grabs when it comes to administrative coherence. We don't accept that at all. We say here it is about the illogicality. In other words, why would a state act in one way, in a positive way, in other words, providing the gender reassignment surgery, but then not follow through with the consequences of that? So that's the illogicality. It's the impact on the applicant rather than the impact on the state.
But why won't recognition of non-gender status in a passport then be the, if you like, the fulcrum for that argument applied across to other practices?
Well, because in the context of the passport, firstly, it's unspecified. So I make the point again, it's a broad category that, as my Lady Rose put, it could be a cis person, where the Secretary of State would wish. I believe it's Malta. Anyone can apply for an ex-passport. In theory, should that be the Secretary of State's decision. But the second point is, it could not operate as a fulcrum any more than, as it were, Goodwin tells you that for all purposes, therefore there must be identical rights. So, for example, when it comes to Hämäläinen and the marriage question, in Hämäläinen, the question was whether a person who had transitioned could remain married or was required for their marriage to be converted to a registered partnership. And the court said there was a registered partnership process that was of adequate proximity to marriage, that there was no positive obligation. The balance didn't give rise to any positive obligation to require marriage. So it doesn't follow from the fact that there would have been an acceptance, or a reluctant acceptance by the part of the Secretary of State, or a finding by this court of a positive obligation, that a positive obligation might arise in some other context. It doesn't follow in relation to a trans person in Hämäläinen, no more would it follow in relation to a non-gendered person as a result of a decision of this court that a positive obligation arose in relation to passport. We say there's no necessary connection between them.
Yes, thank you.
So then moving to the factors in relation to the state, the first factor identified by Hämäläinen is not in dispute. Our alleged obligation is narrow and precise rather than broad and indeterminate. That is accepted and was found by the Court of Appeal, paragraph 53, page 270. We then come on to the Secretary of State's argument of that there is a need, in the context of a burden on the state, a need for an administrative coherent system for the recognition of gender.
Sorry, I didn't catch that.
I'm sorry, a need for an administratively coherent system for the recognition of gender. And the Secretary of State bases this proposition on a series of decisions of the Strasbourg Court and one in the domestic court. My Lord Sales has already pointed to paragraph 78 of Goodwin. If I may also just refer to paragraphs 86 to 88, which are also relied upon by the Secretary of State, page 724. And one will see, just so that we're clear, this is under the title Impact on the Birth Register System. So this is the impact on the state. This is the countervailing factors that go to state rather than applicant. And here the court considered the question of the impact on the birth register system. So, of course, that was the challenge. That was the target of the challenge. In other words, that the birth system had to be changed such that the acquired gender could go on the birth certificate with all the consequences that flowed from that. And we accept, of course, that that was a factor that was identified as being relevant to the burden on the state in Goodwin. However, the birth register certificate was effectively at the heart of what was being claimed. In other words, that in order to recognise the legal position of a post-operative transgender person, such as Christine Goodwin, the birth certificate would be required to be changed. So it is not concerned with the coherence of other parts of government policy. It is the actual measure that is impugned. In other words, the government says, well, you can't possibly change a birth certificate because it is a historical record. Now, the court in Goodwin doesn't agree. The court says, well, actually, you can change it a bit, and we don't think this is quite so significant. And you've issued some proposals for reform in any event. But it emphasised here the detriment to be suffered by third parties, and that was a detriment that was identified in Rees, who wouldn't be able to look at the birth register system. So when it came to burden on the state, so far as access to the birth register system is concerned, that gave rise to potentially interference with the rights of others. And in Rees, maybe enough just to give my Lord the references, in Rees, paragraph 43 at 2199, there what was considered was the impact on third parties such as public authorities or life insurance companies in relation to information they had a right to receive. So the argument went far beyond and wasn't based on, we say, coherence, administrative coherence generally. The argument was based on the actual document which would be required to be changed and how that would then affect the rights of third parties. So one can see there that when a third party right is involved, you can see why that was a factor that went to the burden on the state and the impact on the rights of others. So insurance companies who might not be able to give the right premium and make the right adjustments depending upon what the birth certificate said, which would then reflect an acquired gender rather than one assigned at birth. So we say that equally these paragraphs of Goodwin are not in support of the general proposition that administrative coherence generally, beyond the measure in question, is a relevant aim which can be relied upon when dealing with the burden on the state. Can I pick up the series of cases that the Secretary of State relies upon in relation...
Can I just ask why you don't claim in relation to the birth certificate system in addition to the passport system?
The passport is issued under the royal prerogative and therefore requires no legislation. This is a document which the appellant has been seeking for a number of years. It might be regarded as a short and immediate way in which to alleviate much of the difficulty faced by the appellant of having to provide identification documents, whether travelling or domestically, which misrepresent the appellant's gender identity. Now, that is the choice of claim. If we are to be criticised for not being more ambitious, then I would take that criticism, but one would have thought the Secretary of State would be as it were, appreciative that we have narrowed our claim because it does not, in particular, require legislation. So there is no question here that the policy would be complicated to change in and of itself. There is no need to wait for parliamentary time or the like. There is no need for consultation, we say. So in this case, the appellant chose to challenge in particular a system which ought to have been readily remediable, we say, a number of years ago, but still, of course, remains as it is. But we say that the appellant shouldn't be criticised for not bringing a wider-ranging claim, just as the applicant in B in France shouldn't be criticised for focusing their challenge on the documents that they were required to provide on a daily basis. So, my Lord, just then going on to the other cases that are relied upon to suggest that Strasbourg has accepted administrative coherence more generally, the AP Garçon case, if I may pick it up, it starts at 647, and if I may pick it up, it's 677. So this is in relation to civil status documents in France. And if I may pick it up with the nature of the argument, which is there was a requirement in the French system to demonstrate an irreversible change in appearance. And the applicants there argued that that amounted to requiring sterility. One sees that from paragraph 2. And at 103, one sees the applicants' arguments that were set out in their application. And if I may pick it up, I think 9 lines from, or perhaps midway down, do my lords, my ladies have a passage that begins, furthermore, this approach could not be justified. Just after halfway through that paragraph 103. So this is what the applicants submitted. And this is the suggestion that you had to demonstrate an irreversible change in appearance, and they said this could not be justified by the irrational fear that individuals would be able to have the gender markers in their civil status document altered indefinitely and on a whim, thereby jeopardising the principle of the inalienability of civil status. And that was the applicant's argument. The government's argument appears at 105. And that's at page 678. And there they suggest that the refusal of the applicant's request had pursued a legitimate aim. It had been guided by the French principle of the inalienability of civil status, according to which a decision to amend a birth certificate could not be a matter for the individual's choice alone, even though that choice fell within the sphere of respect for private life. It was because the reliability and consistency of French civil status records were at stake, and in the interest of the necessary structural role of sexual identity within the country's social and legal arrangements, that a change of gender could only be permitted when the irreversible nature of the gender reassignment process had been objectively established. In other words, they, as it were, are dealing with the question about not being allowed to alter a civil status on a whim, but only with certain established principles. And then the part relied upon by my learned friend is page 687, paragraph 141. I may pick it up there. The court notes, just nearly at the bottom, that the requirement, that is to, this is to prove the existence of a gender identity disorder. I'm so sorry. The requirement in this case was that they didn't embark unadvisedly on the process of legally changing their identity. And then this is the part relied upon by the Secretary of State. It points out that in that regard, the interests of the second and third applicants overlap to some extent with the general interest in safeguarding the principle of the inalienability of civil status, reliability and consistency of civil status records, and legal certainty, given this also promotes stability in changes of gender in civil status documents. So what is being said there, again, we say is not administrative coherence as a principle is a legitimate aim. What is being said there is that the inalienability of civil status, in other words, you can't change it on a whim, justifies a requirement that you have to prove the existence of a gender identity disorder, because we see the arguments that were made about inalienability. So we say that is really part of an implementation question. In other words, what does the individual need to demonstrate in order to change their civil status documents? Here, you had to demonstrate a gender identity disorder because that is consistent with not allowing people effectively to change their gender on a whim. So we say that, again, doesn't support the Secretary of State's position, which is, in principle, administrative coherence between a particular policy affecting only passports, but that they want to regard, in a wider context of gender identity recognition more broadly, is a legitimate aim in the context of Article 8 and whether a positive obligation arises. Also, maybe just quicker to give the references again, can I just pick up a similar point that's made in SV in Italy? That's at page 2298, paragraph 69. That case concerned a requirement that an amendment to the civil status records of a transgender person had to be ordered by a judge rather than by an administrative process. So there, this point that was made about administration was simply, was it acceptable that a judge was required to do that rather than an administrative process? And it was found that it was. And it refers back to the AP Garçon decision. So again, it's not about administrative coherence and legitimate aim. It was which entity should make the decision as to the point at which civil status could be changed. And we simply note that a very helpful clarification appears in XY in Romania at 863, paragraph 158, where they refer back to the Garçon cases and SV Italy, and they point out that justification is the establishment of rigorous procedures that aim in particular to check the underlying motivation for a claim for legal change in identity. So it goes to the heart of the implementation question that's flagged up in Goodwin. In other words, how you actually go about giving effect to the more general recognition that a person has a legal status in their acquired gender. So again, we say that that doesn't support at all recognition more broadly of some legitimate aim of administrative coherence. Domestically, the Secretary of State relies upon McConnell and the Registrar General. This is at 1387. And it might be worth, given that this is a Court of Appeal decision, just turning this up so we can see it. It's the case that was previously referred to as TT, and it involved the question of the use of the appellation mother on a birth certificate by a transgender male. And at 1387, we see paragraph 58 right at the bottom, where the question was asked whether there's a legitimate aim for the interference. Now, of course, I recognise that's the this is a negative obligation context, but this is relied upon by the Secretary of State. The question is whether there's a legitimate aim for the interference. It says there clearly is. It consists of the protection of the rights of others, including any children who are born to a transgender person, and the importance of a clear and coherent scheme of registration of births. Now, the Secretary of State, of course, relies on the second part of that sentence, but we say they cannot be read separately. Because the Court of Appeal goes on, it's important in this context to bear in mind this is a question to be addressed at a general level. They point out it doesn't turn on the facts. And just at the end of that paragraph, the question is whether the rights of children generally include the right to know who gave birth to them and what that person's status was. So it is very clear that the right that the Court of Appeal was concerned in McGonnell, previously TT, was the right and protection of others. In other words, a child who was born to a transgender person. So there is no separate legitimate aim of administrative coherence. And we note, of course, at the beginning of paragraph 58, the question is asked, is there a legitimate aim? And they say there is, it consists of, there is one aim that are not separable. And we say that it is entirely understandable why neither the Strasbourg cases or McConnell support the Secretary of State's position that when considering whether a positive obligation arises and the fair balance could be struck, that the interests of the state include, or could be based on entirely or partly, administrative coherence. And we say that because, as I emphasised at the outset, it is well established that the applicable principles under Article 8 are the same. They're comparable or similar in relation to positive and negative obligations. Of course, as in McConnell, if it's a negative obligation, the interference would need to be justified as being in accordance with the law, necessary in a democratic society, and in order to achieve one of the legitimate aims enumerated in Article 8.2. And those aims are exhaustive and restrictive. And if I might ask my lords, my ladies, to go to YY and Turkey at page 935. A very helpful analysis in my submission by the court on what that really means in practical terms when you're thinking about Article 8.2. And at paragraph 76, the court reiterated that the enumeration of the reasons capable of justifying interference with the right to respect for private life, as listed in 8.2, is exhaustive and their definition is restrictive. And it makes it clear that an instance of interference, for it to be compatible, must pursue an aim that can be linked to one of those listed in this provision. It notes the court's practice is to be quite succinct when it verifies the existence of a legitimate aim within the meaning of the second paragraphs of Article 8 to 11 of the Convention. But they say in that case, because the applicant contested the relevance of the claim, the court set out its position in greater detail. Now here, again, this is a gender recognition and reassignment question. The government in Turkey had argued that the regulation of gender reassignment fell within the sphere of protection of general interest and was aimed at preventing such surgery from becoming commonplace and preventing improper use by certain sections of society, especially the sex interest. And it also referred to protect the interests of the individuals concerned because of risk for physical and mental well-being. The court in Turkey wasn't persuaded that the arguments concerning the risk of it becoming commonplace or misused were apt. In particular, it was not convinced that the aims relied upon in that regard fall within the category of the legitimate aims set forth in Article 8.2. It then go on to deal with the legitimate aim of a health risk to the individuals concerned. But we say it is relevant to note then that restrictive and exhaustive approach that is taken in relation to Article 8.2, and particularly in this context, where on one view an aim to prevent improper use by sections of society, including the sex industry, might perhaps be thought to be a more coherent aim in itself when it comes to gender reassignment surgery. But we say what is clear from this case is one cannot simply say administrative coherence, well, that's a legitimate aim under Article 8.2. On the contrary, we say this case is indicative that you have to view those provisions as exhaustive and restrictive, and that if trying to prevent improper use of gender reassignment surgery isn't a legitimate aim for Article 8.2, equally we say administrative coherence, a much further and more diffuse concept, not connected necessarily with the impugned measure in relation to passports and the policy, we say cannot fall within any of the legitimate aims enumerated in Article 8.2. Because if the Secretary of State is right that administrative coherence as a concept is a legitimate aim, then it would cause the most remarkable skewing of the position between a positive obligation under Article 8 or a negative obligation and the legitimate aim that may be relied upon to justify it. And we say there is no justification in any of the authorities relied upon by the Secretary of State to suggest that when you are considering the question of whether the positive obligation arises, and I'm setting aside the question of margin here, it is the factors that go to the impact on the state, that the legitimate aim pursued can simply be one of administrative coherence per se. We accept, of course, if it comes to the impact on the particular measure, the birth certificate in Goodwin, for example, but that is a different question to administrative coherence when there is no necessary connection between the measure impugned and other types, as my Lord Reid put, other types of situations, such as a prison or a pension situation. So we say that that imbalance doesn't find any support anywhere in the Strasbourg jurisprudence, and on the contrary, the restrictive and exhaustive approach to Article 8.2 potential legitimate aims should be followed here. Can I just deal then briefly with the existing absence of coherence? It's a point that we made in the Court of Appeal. In other words, and I've already highlighted the point, in other words, if a trans person currently can obtain a passport in an acquired gender without gender recognition certificate, without surgery, but simply with a doctor's letter to the effect that the change of gender is likely to be permanent, if that is right, then there is already exactly the problem that the government suggests is so problematic, that a person is treated by HMPO for the issuance of a passport in a different way as they are treated by other government departments. And that's the Secretary of State's written case at paragraph 30, page 209. So that position has pertained throughout. It goes back to Rees, where we know that you could obtain a passport as a operative transsexual with no difficulty at all, the minimum of formality. And it has been maintained since the introduction of gender recognition certificates, which are not necessary to change on a passport. The only answer that the Secretary of State has is, well, that's different because it is in relation to M and F. In other words, it relates to a change from M to F or F to M. But that cannot be an answer to administrative coherence when the Secretary of State recognises that there is a fundamental incoherence, and has been for decades, between the position of passports for trans persons and the position for them in relation to other parts and facets of their existence. And we note, of course, that when the Court of Appeal says, well, actually, my point supports the Secretary of State's position, administrative coherence is desirable, well, there has been no attempt to change this position. On the contrary, recent consultation on the Gender Recognition Act has not suggested any change to the methodology by which a trans person obtains a passport. So this is an incoherence that the Secretary of State is fully happy to live with. And we say rightly so. But then it, we say, lies ill for the Secretary of State to suggest that there is an incoherence that is unsupportable when it would come to a non-gendered person having an unspecified passport, but being treated in different contexts by different government departments, not as having X, as it were, for unspecified.
Can I just check when that practice was adopted? Did it come in after the 2004 Gender Recognition Act, or was the Passport Office already doing that before the Act?
It's already doing that before the Act, because that's why I went to Rees, because we see from Rees they can do it with a minimum of formality. So
right.
We see it from Rees and we see it from COSI.
So when did it start?
Well,
do we know?
No, but I know that Rees concerned a position in. It was in 1986 was the hearing, and I don't think it says when Rees had obtained their passport, but the application, so it must predate 1996. The proceedings were lodged in 79.
Thank you.
I don't know whether Sir James will be able to help on that, but as it were, it is decades long, that position. And the key point I emphasise is it isn't an inconsistency that the Secretary of State has ever sought to amend, not even in the most recent, in the last few years, consultation on the Gender Recognition Act. And we emphasise again, we say so far as administrative coherence is concerned, there would be far less, even assuming the Secretary of State is right that this is a relevant consideration, far less incoherence between a non-binary person and a non-gendered person having an X in their passport than there would be, or there is currently, in relation to a trans person. Because with a trans person, the documentation would say M, for example, in a passport, and F in every other walk of life. Here, in relation to a person such as the appellant, it would say X for unspecified. So there is less incoherence by a very large margin. We say there is none because there's no necessary link between the passport policy and other parts of policy or law, but one can see that the incoherence is very, very much less. I also simply note that even gender recognition certificates don't change a person's gender for all purposes. That is made clear in a helpful summary in C and the Work and Pensions Secretary, page 1216, paragraph 23. It doesn't affect legal status as a father or mother of a person's child, For example, it doesn't mean that a person can't be excluded from sporting events in which a person is seeking to compete in the acquired gender. Topical at the moment in relation to the Olympics and a particular potential athlete. And it also doesn't change the law in relation to gender-specific offences. So already you have a number of, no doubt, very carefully calibrated distinctions. But those make it clear that there is no necessary, as it were, coherence argument. In other words, a person must have M for every purpose and not F, because that isn't the case in relation to transgender persons, and we say it follows a fortiori that there's no necessary connection between having an X in a passport for unspecified and being identified by the birth, the sex or gender assigned at birth in other parts of one's life.
But that's assessed by the perspective of the person involved, not by the perspective of the legislature?
In relation to the trans position, my lady?
We were talking, weren't we, about non-gendered?
Mm-hmm. So
what you're saying is, well, it may be the non-gendered person would not be concerned about coherence, because as long as he's got his passport, he's got something to show for identity. But haven't you got to look at the perspective both ways, to the state and the individual?
well, my point, my lady, would be that actually that's just the same for a trans person. So a trans person might identify in an acquired gender, have had no surgery, not have a gender recognition certificate, but all they would have is a letter from a doctor saying that the change of gender was likely to be permanent. It isn't even that it is likely to be permanent. Now, that is, as it were, self-identification plus, if I can put it like that. If the government considered it's necessary to have self-identification plus in relation to a non-gendered person, then that would be a matter for the government. We say on any view, the appellant, having gone through 2 surgeries and identified for 30 years as non-gendered, and I say identified, I made it clear at the outset, the appellant from childhood realised a separation and a dysphoria, but fully transitioned to a non-gendered status 30 years ago. So there could be no question but the appellant would fall within that, were the government to adopt a similar approach to a non-gendered person as they do with a trans person in relation to passports. So, I take your point entirely, and I think it goes, doesn't it, to the question about a whim, whether one could simply would just decide that they want to be X rather than M or F. Malta, I believe it is, allows a person to do that. This government may not think that's appropriate, but that is a question of implementation, and we aren't at that point yet. But I say, in any context, we are people who would fall within a category whereby there's a positive obligation in relation to an ex-passport. Well, may I move very quickly? I hope I can move very quickly to the question of security. Now, I accept that security is in principle a legitimate aim under Article 8.2, and so...
Sorry, you accept
I'm
that?
sorry, I was racing through before the lunch, Chairman. I accept that security is in principle a legitimate aim under Article 8.2, that exhaustive list, and it is therefore relevant in considering the content of any positive obligation in this context. Now, before the High Court, the Secretary of State relied upon 3 aspects relating to security. The first, combating identity theft and fraud. The second, security at national borders. And the third, the personal safety of the passport holders. That's set out at paragraph 52 of the judgment of the High Court at page 313. As set out at para 72 of the Court of Appeal's judgment, page 274, by the time of the Court of Appeal, the Secretary of State relied on only 2. It had jettisoned any reliance on the personal safety of the passport holder. We are now at a point where the Secretary of State relies upon a slimmed-down version of combating identity theft and fraud. It is simply the issuance of a passport and security at national borders. Can I deal with issuance first, and hopefully relatively briefly? The evidence filed by the Secretary of State is at page 453. And this is partway through. I'll pick it up. This is the witness statement of Timothy Woodhouse, whose title is enormously long, but he's the acting, then was, Head of Illegal Immigration, Identity Security and other matters at the Home Office. And he made it clear at paragraph 27 he says, paragraph 27, principally sex is relevant when issuing passports. It's a recommended requirement for machine-readable passports by the ICAO. By abiding by such recommendations, we ensure the UK passport is accepted around the world. Now, that was the point my Lord Reid asked, as it were, why is that relevant? And that's because it's the starting point for the government's approach to its policy. Paragraph 28, gender is one of the number of identifiers that enables HMPO to be satisfied with the identity of person before a passport is issued. And they make the point if the gender on the application forms is not matched with the gender of an applicant, it could indicate potential fraud, and refers to the Gender Marking Passports Review at section 3. Can I just deal first of all with the point of principle? If a person applies for a first passport, they will need to present a birth certificate, irrespective of whether you're seeking an M, an F or an X birth certificate. That is the position for currently seeking M and F. No issue arises there. If a person who holds an M or F passport were to apply for an X passport, well, that might be flagged as a discrepancy between the two passports. HMPO can make further checks. That check would no doubt involve asking for a copy of the birth certificate. Or it might consider that he had other documents it could look at. If a holder of an X passport applied to renew, then there's no discrepancy, so in principle no fraud. But if HMPO considered it wanted to make further inquiries, it could do so, and it could ask to see the original birth certificate. So even if the government's right that a mismatch, in other words, I put on the box that I want an X passport and I provide a birth certificate that has F for female on it, even if there is that mismatch, well, then that is readily reconcilable by simply asking for a birth certificate. And it means actually fraud is more likely to be detected than not in the case of X passports.
So what, the birth certificate will show F?
Yes, it will. But the individual concerned would still be applying for an X passport, be unspecified. And that's when you get to the question of, as it were, would with a trans person currently under the guidance, which is what else do you need to provide to have a passport issued other than on the same gender as is on your birth certificate. So that's exactly the same position. There, you'd have to provide a deed poll if you changed your name and the doctor's letter saying it was likely that you'd continue in your required gender. So we don't say any complication or problem or difficulty with fraud arises. So we just don't see or understand how the issuance of a passport could give rise to a question of fraud if a person applied for an X passport. We simply don't follow that. The sex marking review appears at 459. This was a review on the use of sex markings in travel documents. This follows, just to put it into context, this follows the Women and Equalities Committee report and the recommendation that the UK must introduce an option to record gender as X. And the government then carries out a survey, and one sees at page 462 that it wasn't the most well responded to survey ever. It had circulated a questionnaire to 170 member states, this is the second paragraph down, and only 21 member states responded. So the sample is too small to be considered representative of all member states, and the response rate is too short to be able to draw any reasonable conclusions. So that's the status of this document.
And can I just check, when they talk about member states, that's members of the International Civil Aviation Organisation?
Exactly,
okay.
my Lord, yes.
Can I ask, this document was issued by the Home Office. Is Her Majesty's Passport Office an executive agency of the Home Office?
The nomenclature might, for a moment, the Passport Office is part of the Home Office, as it were, for those purposes, hence the challenges to the Secretary of State. But whether it's an at-arm's length government body, I'm sure Sir James will be able to tell me that right. the nuances are perhaps even more complicated than before. But I can double-check that over the lunch adjournment. But it's, for these purposes, it is part of.
Yes, and ministerial responsibility presumably rests with the Secretary of State for the Home Department. Yeah. That's
not in dispute. Exactly how one gets there might be a different question. So just picking up then, if I may, then on the the sex marking review and passports, the part relied upon by the Secretary of State is that 10 out of 21 respondents identified concern that removing passports would have a detrimental, removing sex markings would have a detrimental effect on identifying and verifying the holder. one sees that from page 465 under section 5. So it's under the context of disadvantages to removing sex/gender markings. So these comments, even subject to the caveat that they're not representative and can't be relied upon, these comments are about disadvantages to removing markings. And in any event, they appear to be dealing with identifying people at borders, but not at the point of application, but that might take us any further. But that, of course, isn't the question here, which is the inclusion of an X marker as well as M and F. So we say that this simply is nothing to the point, and in any event, evidence of the slightest value as accepted in the foreword to the report. Now, border security was dismissed in terms by the Court of Appeal. Paragraph 73 at 274, issues of security do not affect the fair balance in circumstances when the ICAU has for many years been content for passports to carry an X marker. Additionally, people from countries that have such provision have been entering the UK for many years without there being any security issues articulated before us, and any marginal value in combating fraud and theft does not have any impact on the important aspect of gender identity. Now, we say that was entirely right. Again, the Secretary of State says that that finding doesn't engage with her expert view, supported by the findings of the sex markers review, that that marker, taken in conjunction with other markers, is an important component of a wider data set that contributes to identity verification. That's paragraph 47 at 215 of the written case. We think that the statement that's relied upon is one that appears at section 6, if one turns to page 467, under the conclusion passage. In the second paragraph, it suggests that on the whole, this review has found the removal of sex-gender markings was not supported by the majority of the responding countries, all 21 of them. Although sex-gender as an identity marker was seen as limited value in its own right, considered in the context of multiple markers, it's currently an important component in wider data sets that contributes to identity verification. So again, it's unclear where that conclusion comes from, but it might be that it comes from border control, which starts at page 465 to 466, because, of course, that's the issue that the Secretary of State relies upon. But the concerns there in those paragraphs under border control are only expressed by 7 out of 21 respondents in total. And we also note that in relation to border control, for completeness of 463, 14 out of 18 responding countries said that border control officials visually identify travellers using the recorded sex gender as one element against which to confirm the person's identity. We say that the Secretary is right not to rely upon that. It is based on an outdated and misguided assumption that a person's gender will necessarily correspond with the stereotypical idea of male or female appearance. So we say that to the extent that that might be the, as it were, the majority view that's relied upon, it would be wrong in any event. So far as security is concerned, there simply is no evidential basis for the Secretary of State's suggestion that there is some adverse impact or detriment to the state so far as the interests of security are concerned. I'm about to move on to the margin of appreciation. I'm very happy to start it in the next 2 minutes, but it might be that my lords and my ladies would prefer me to start on a new topic after the lunch adjournment. I'm entirely in
Yes, we're slightly past 1 o'clock, so I think we're best to adjourn just now and resume at 2 o'clock.
I thought I was early from that clock, but clearly it wasn't pessimistic.
I'm afraid that the clock can't be relied on.
I will learn that for next time. Thank you.